The National Lands Commission (NLC) has moved to intervene over a land dispute pitting Maki Estate residents and Chania Enterprises Ltd, who are the original owners of the over 1,000 acres of land in Gatanga Constituency. According to the residents, the developer had reneged the original demarcation plans, after he started subdividing and selling some 20 acres parcel of land that had originally been set aside for public use and recreational purposes. The residents claimed that the over 300 families who live in this 400 acres of land have no place to put up facilities such as health centers, schools, places of worship, police station and children's playground, as the developer has already sold it to other people without their consent.
See, I think both sides. Each one has a complaint, and we've had a series of meetings in the office. So today I needed to see and understand the complaints. We've gone round.
My name is Julius Jugona Wanyoike. I'm the Diocesan Bishop of Thika in the Anglican Church, and I'm also a resident of Maki. This morning we are gathered with the members of the Land Commission so as to arbitrate on the pieces of land that revolves around social amenities which the community has been seeking. It is expected that every place where there is demarcation of land, we have lands set aside for social amenities such as a police station, a school, a clinic, or even a church, a mosque, or a temple where it can be constructed. It is important that generations to come will find such places in a place like Maki and in other parts of Gatanga where land is being demarcated and given back to the county government and to the National Land Commission for determination on who eventually should be the trustee of the public land.
Peter Jogona Mwangi, Chairman Maki Estate. The families here are around 300 homes with an average of 5 people per family. That's around 1,500 people. And all these people are just living in a place where there are no amenities. The population is increasing because every year new plots are being built up. Therefore, the population here is just increasing, but unfortunately, we are caged in our homes. We realize that there are no public amenities in our area, which had been indicated in the maps that we used to buy the plots here. But later on, Chania Enterprises, who sold us those plots, they came back silently. They started demarcating those plots and selling them. We raised up the matter, we called him, we discussed, and he told us that he was going to get a solution. So for the last 4 years, we've been having meetings both on the ground and also in Nairobi. And this meeting today was the combination of all these other previous meetings. And we are hoping that it will be the last, and that National Land Commission is going to pass a verdict showing where the public amenities should fall, so that the residents of Maki can have places where they can be able to recreate and to unwind.
While responding to these allegations, the developer, through his lawyer Geoffrey Nyakundi, insisted that at no point had the land in question ever become a public utility. He said that the parcel in contention had initially been set aside for a private golf course before the owner later changed his mind. He added that Chania Enterprises Ltd had followed all the laid-down procedures and ceded off all the necessary provisions as demanded by the then local authority, therefore, saw no reason why the residents laid claim for land that was private.
My name is Geoffrey Nyakundi. I'm an advocate for Chania Enterprises Ltd, who's the seller. Yeah? So originally this parcel of land constitutes about 1,000 acres. Our client has managed to subdivide and sell approximately 400 acres. So there's a balance of about 600. So at one point, our client did a subdivision of a section of the larger land, which constituted about 20 acres. And initially he wanted to develop that as a private mini golf course, but over time it did not make any commercial sense, so he decided to apply to the authorities for subdivision. There have been other issues that in the initial master plan for this subdivision, in the larger subdivision of the 1,000 acres, there were spaces set aside for church, spaces set aside for other public use matters. This land originally was all private land, has never at any given time, save for the colonial period, constituted public land. Okay? Under those circumstances, then public land would only arise if the owner, which is Chania Enterprises, would surrender that land to the government. The government, upon subdivision, did conditions, okay? Made conditions for that subdivision, and the conditions were surrender all the roads, period, nothing else. We surrender the roads, they are owned by the county government. There was no requirement to surrender to the government any other plot here. For us, we're inviting the commission to determine whether that contentious piece of land that was originally stated as a playground constitutes public land. Okay? If the commission comes and says yes, it was public land, then we will either agree with it or take up the next step. If they say it's not public land, then this puts to rest all this conversation.
On its part, the NLC through Commissioner Esther Marugi Mathenge said that they would go through the evidence gathered, both on paper and on the physical tour of the land, to make an informed decision and according to the law. She urged county governments not to approve land developments that had no provisions for public utilities. Gatanga MP Wakili Edward Mariu hoped for a win-win amicable solution to the entire matter for the two parties in dispute.
The reason we are here today as the National Land Commission is because a complaint has been brought to the National Land Commission by the buyers of the Maki Estate, as well as the Maki Estate themselves. And in issues of land, you cannot make determinations when you're in the office. It is important for us to come to the ground so that we can appreciate the complaints that have been there. So today's exercise was to see the areas that the Maki residents are complaining were public land and now seem to be bought or being sold by Maki. So these are areas where they were planned for schools, for markets, for health centers, and also for sports areas and recreational areas. We are working jointly with the county government so that they can also be part and parcel of ensuring that persons who are subdividing land ensure that there is enough public land that is left for the people who are buying those subdivisions. Because you'll find in some subdivisions or in some areas, you have an estate of over 200 households, but you don't have a playing area for the children. You don't have a nursery. You don't have a security area. So those are things that we are saying are a must. And once the subdivision is done, they must be vested to the relevant government, maybe national government or the county government.
We have physical planning rules and regulations whereby whenever there is subdivision, land for public use must be set aside, for schools, for churches, for communities must be set aside. It's one of the conditions for subdivision. And therefore, one of the key things I'm here today is to ensure that the Land Commission meets the developer, meets the buyers of the property, meets everybody, and ensure that if there is community land which has been alienated, is taken back to the community. If there's land which belongs to the developer, is given to the developer. And therefore, because all those documentations are there, and our laws are not devoid of any lacuna, especially when it comes to issues of physical planning. And that's why I've requested them to do it. I'm sure at the end of the day, the law, they will follow the law, and the law will be our shield to ensure that justice is done for everybody.